Shall we begin?
Yes, please.
Oh, Madhu sir, we are ready.
Yes, you can start.
Am I audible?
Yes.
With your lordship's due permission, the council seeks permission to proceed.
Yes, please.
The council, acknowledging the presence of your ladyships, would collectively like to address the bench as your lordships and individually as your lordship and your ladyship.
Yes.
Much obliged, your lordship. Your lordship, we are the counsels for the petitioners in the case of Kobayashi Constructions Limited and Lim Green Energy versus Airport Authority of Vindhya. This is counsel number 1. And counsel number 1 will be taking 20 minutes of this court's time and will be dealing with issues 1 and 2. My co-counsel is present here, who will be dealing with issues 3 and 4, reserving 21 minutes of this court's time. And we've respectfully reserved 4 minutes for our rebuttals. Your lordship, the council seeks permission to state the facts.
Please skip the facts as we are already aware of it.
Indeed, your ladyship, the council seeks permission to proceed with the first issue. Much obliged, your ladyship. Your lordships, the first issue being whether the arbitration in the instant case is foreign seated. It is humbly and most respectfully submitted before this Honorable Supreme Court by the counsel for the petitioner is that in the present case, the arbitration is not foreign seated. The seat of arbitration in the instant case is in the country of Vindhya and not at Singapore. The petitioners have approached this Honorable Court by invoking Section 11, subsection 6, read with Section 11, subsection 12 of the Arbitration and Conciliation Act of 1996 for the appointment of arbitrators. Your lordship, the council will be dealing the first issue under 4 sub-issues being international commercial arbitration. Secondly, the council will be clarifying or distinguishing between what is a seat and what is a venue. Thirdly, the council will be putting forth her thoughts on why in the instant case the arbitral status is at Vindhya and not Singapore. Fourthly, party autonomy principle, which is one of the essential factors, especially when it comes to arbitration proceedings. If your lordships do not have any preliminary queries, the council seeks permission to proceed with the first sub-issue. Much obliged, your lordships. The first sub-issue being international commercial arbitration. It is humbly submitted that arbitration in the instant case is of the nature of international commercial arbitration as defined under Section 2, subsection 1, clause F of the Arbitration and Conciliation Act 1996. There are 3 factors which are essentially which have to be complied with, being arbitration. Secondly, commercial under the laws in force in India. Thirdly, at least one of the parties is a national or a habitual resident in any other country other than Vindhya. In the case at hand, the respondent here is the Airport Authority of Vindhya, who is a statutory body established in the year 1975 as per the laws of Vindhya. Secondly, the petitioners are 2 in number. Firstly, the Kobayashi Constructions Limited is a multi-conglomerate based in Singapore. The second petitioner here being Lim Green Energy, who's a wholly owned subsidiary who's also based in Singapore. Your lordship, moving on to the second sub-issue which the council will be putting forth with your lordship's due permission is that the distinction between the seat and venue of arbitration in the present case. Your lordships, it is humbly submitted before this Honorable Supreme Court that there is a distinction between the seat and the venue of arbitration, and these two must not be used interchangeably, especially when it comes to international commercial arbitrations. This assumes a great significance. Seat is a place which confers the courts a supervisory and a governing power over the arbitration proceedings, whereas venue is a place or a mere geographical location where hearing of witnesses, the parties, the inspection of goods is conducted and concluded. Your lordship, the council will be referring to Roger Shashoa versus Mukesh Sharma, which is highlighted in page number 1 and 3 of our compendium. that is venue should not be synonymous with that of the seat, and the similar has been established in the Balco versus Kaiser Aluminium Technical Service Limited case. Your Lordship, the seat assumes the center of gravity of the arbitration, and it is where the arbitration is anchored. And the similar was given in LMJ International Limited versus Sleepwell Industries Companies Limited, whereas the venue assumes a geographical place where the meeting is conducted. Your Lordships, further, the main limb of my first issue, that is, in the instant case, the arbitral situs and the seat of arbitration is in the country of Vindhya and not at Singapore. It is humbly implored before this Honorable Supreme Court that in the instant case, Vindhya should be regarded as the seat of arbitration and not Singapore, because the same was agreed between the parties at the time of entering into the contract. If your Lordships, I would like to draw your Lordship's attention towards the dispute resolution clause provided in the annexure, Article 17 dispute resolution, wherein it states that this agreement shall be governed and interpreted in accordance to the laws of Vindhya, and the courts at Gotham City have jurisdiction in the matters arising out of this agreement. It is humbly submitted that the language used in the agreement should be construed in a holistic manner to ascertain the true intention between the parties so as to determine what forms the seat and what is the venue of arbitration. Your Lordship, the Council will be relying on Mahanagar Telecom Nigam Limited versus Canara Bank, which is in page number 47 and 48 of our compendium, wherein while deciding that particular case, the designated judges have quoted Enercon India Limited and others versus Enercon GmbH, wherein the courts have iterated that a common sense approach has to be adopted to give effect to the intention of the parties to arbitrate the disputes between them. This being a commercial contract, the arbitration clause cannot be construed with a purely legalistic mindset as in case of the statute. Similarly, in 9.6 of the same case, in Karda Company Limited versus Raymond and Company Private Limited, the similar has been iterated by this Honorable Supreme Court.
Counsel, what would you say regarding this 17.2, which seems more specific clause, any reference to arbitration shall be at Singapore? Why that should not be treated as the seat rather than going by the generic one, which is in 17.3?
Indeed, Your Lordship, the Council will be clarifying this immediately. Your Lordship, I would like my co-counsel to direct Your Lordship's attention to page number 23 and 26, wherein in the similar Enercon India Limited and others, Enercon GmbH, wherein the Honorable Court has highlighted Navera Amazonica Peruana case, wherein Your Lordship, there are three laws which govern the arbitration agreement, them being Lex Loci Contractus, which means the law which governs the substantive law as the contract as a whole. The second being Lex Arbitri, the law governing the arbitration agreement. And the third being Lex Fori, that is the law governing the conduct of arbitration. The Council has put forth these three laws, especially in front of Your Lordship, because if we construe 17.3, it states that this agreement shall be governed in accordance with the laws of India, but clearly states that in the present case, Lex Loci Contractus is in accordance with the laws of India. That is, the contractual law is in accordance with the laws of India. Coming to Your Lordship's question, which Your Lordship has pointed out, is with respect to the Lex Arbitri and Lex Fori. That is, when we look into section 7 of the Arbitration and the Conciliation Act, it states that section 7 defines what an arbitration agreement is, wherein if section 7 subsection 2 is read with section 7 subsection 5, it is clear that this agreement provision in 17.3 can be construed as a separate agreement. If I may read it out aloud, section 7 subsection 2 states that arbitration agreement may be in the form of an arbitration clause in a contract or in form of a separate agreement. Subsection 5 of the same section, it reads that the reference in a contract to a document containing an arbitration clause constitutes an arbitration agreement if the contract is in writing and the reference is such as to make the arbitration clause as a part of this contract. Your Lordship, now if we sever this agreement from the 17.3 and construe that to be the arbitration agreement, then now if we conjointly read the entire 17.3, it is the party's intention here is clear, crystal clear, because it states that this agreement shall be governed. It imposes an obligation by stating shall be governed in and interpreted in accordance to the laws of India, and the courts at Gotham City have the jurisdiction in matters arising out of this agreement. This agreement in the sense the contract as a whole. Your Lordship, the council would like to make an humble submission that here in the instant case, lex arbitri determines the lex fori, which is the seat of arbitration. Since all the three laws the council has put forth before this honorable bench, it is implied that the seat of arbitration is in India and not at Singapore. If your
And in
Lordship,
which council, then in which instance 7.2 will be applicable according to you?
Your Lordship, if we construe in the instant case, Article 17, which is the dispute resolution clause, is silent as to what is the seat and what is the venue. There has been no express mentioning of such words. At the time of entering into the contract, if there were any specific words mentioned as to this place will form the seat of arbitration.
No, I'm not on that. We are not on.
Indeed.
I would only like to know.
Indeed.
We have now what is placed before us is a dispute.
Indeed, Your Lordship.
It will be covered by an arbitration.
Indeed, Your Lordship.
It is your case that 17.3 is the one which will be governing it.
Indeed, Your Lordship.
I would like to know what all will be captured under 17.2. What is the relevance of clause 17.2?
The relevance of 17.2, especially the words at Singapore, merely states that in the instant case, it is just a geographical location, that is the venue and not the arbitral seat, Your Lordship. Because Your Lordship, if we construe it in, if we read the sentence as a whole, it states that any dispute, controversy arising out of in connection with this contract, including any question with respect to its existence, validity, or termination, shall be referred to and finally resolved by making a reference to arbitration at Singapore. Your Lordship, it is submitted that in the instant. The council seeks 10 seconds time, Your Lordship.
Council just would like to know, is it possible that the arbitration proceeding is being conducted in Singapore and the laws of India can be applied? Is that possible?
The council would like Your Lordship to repeat the question.
The sense, now is it possible in the current scenario, after all these arbitration amendments and everything, where the seat of arbitration, or rather, let me put it this way, the venue of the arbitration, let's say this entire arbitration is being conducted in Singapore, but according to Indian laws, is it permissible?
That is what the council is trying to put forth before Your Lordship. In the present case, the venue is at Singapore. Then if the seat is at Singapore, then the laws of Singapore will be governing the arbitration, which the council for the petitioners is strictly not favoring. If the venue is at Singapore, then the council, that is what the council is trying to put forth before this honorable court, that even the fourth limb, if I may highlight before, bring to this court's notice, that party autonomy assumes a greater significance, and party autonomy in simple terms means the parties to an arbitration, to the contract, they basically have a right to choose what their seat is, what their venue is, which law, which substantive as well as procedural law will be governing, and in accordance with that, we have followed the same. So the council for the petitioners are urging and imploring before this honorable Supreme Court that Your Lordship has rightly pointed out, we do not have any problem if this honorable court favors and gives a decree that venue is at Singapore and the seat is at India. If Your Lordship,
it is your case that the seat should actually be 17.2 should be read as the seat and 17.3 as what? Venue?
The council begs to differ. 17.2 should be construed as venue in the present case, and the seat is in accordance to 17.3 and seat is in Vindhya.
So yes, there are case laws also to our understanding that in case of ambiguity with regard to the seat, you will have to go away where actually the normal proceedings would actually otherwise be conducted. So 17.3 says with regard to the law relating to cross-examination or production of documents, framing of issues, if all those are covered under 17.3, then ideally the seat should also be India, isn't it?
Your Lordship, the Council has already submitted that lex arbitri here will determine the lex fori, which will determine the seat of arbitration. And in the present case, since Section 7 permits that this agreement can be read as a separate arbitration agreement, and now putting back that agreement in place and reading it as a whole in a sentence, that means both lex loci contractus as well as lex arbitri will be governed and interpreted according to the laws of Vindhya, and therefore the Council would like to resubmit before this Honorable Court most respectfully that lex arbitri determines lex fori, and the same will determine the seat of arbitration, and therefore in the instant case the seat of arbitration is at Vindhya.
A practical question, what is your benefit, Council? I mean, why would you say that let Indian law apply in Singapore?
It is based on the party autonomy principle, and while entering into the contract, we had agreed that the petitioner and the respondent had agreed that we will, it was basically our intention and we are discharging our...
that is fine, no, that's between you parties, but we would like to know why would you emphasize on the fact that let the Indian law apply for an arbitration proceeding that is going to be conducted in Singapore? Why not read that it may be conducted in India itself? How would the balance of convenience is in your favor?
Your Lordship, the Council would like to resubmit that it was the party, based on the party autonomy principle itself.
No, the other side is not accepting, isn't it? No, you cannot say on behalf of the respondent also.
Indeed, Your Lordship.
That the proceeding should be conducted in India according to the Indian laws.
Indeed, Your Lordship.
Want the venue to be in Singapore.
Indeed, Your Lordship.
Say that you participate in the Indian proceeding itself. Let the venue to be in India. How would you be prejudiced by that? Is my question clear?
Indeed, Your Lordship. In the instant case, the seat is in Vindhya, and therefore the laws will be in accordance with Vindhya, which is what the intention of the parties were, and therefore intention of the parties at the time of entering into the contract were, and therefore if we choose the seat as a foreign seat, then the laws governing Singapore will be applicable, which was not the prima facie intention of the parties while entering into this contract.
Okay.
Your Lordship, the Council seeks permission to substantiate this with one more case. That is NTPC Singer and Co., which is in my co-counsel will be directing you to page number 16, paragraph 26, wherein a similar circumstance was brought before this Honorable Supreme Court, wherein they told that there is no need to draw any inference about the with respect to the intention of the parties to impute any intention to them, for they have clearly and categorically stipulated that their contract will be made in India and to be performed in India. Even in the instant case, the airport construction is to be performed in India and made in India, governed by the laws in force in India. 17.3 clearly states that the agreement will be governed in accordance with the laws of India. Courts at Delhi have an exclusive jurisdiction in all the matters arising out of this contract. Even in the instant case, if we look into 17.3, it clearly states that the Gotham City shall have jurisdiction in matters arising out of this agreement. Therefore, the arbitration clause in page number 16 in the same judgment, it's given that the arbitration agreement will basically include the arbitration clause, which is collateral in relation to the main contract. And therefore, since the proper law of arbitration agreement is same as the proper law of contract, the validity, the effect, the interpretation of the arbitration agreement will be governed by such proper law, in the instant case being the laws of Vindhya, Your Lordship. Your Lordship, the Council has already stated about the party autonomy principle, which was her fourth sublim. The Council seeks permission to proceed with the second issue, if Your Lordship. Much obliged, Your Lordship. Your Lordship, the second issue being whether the Supreme Court of Vindhya can appoint arbitrators in the present case. It's humbly and most respectfully submitted before this Honorable Supreme Court that in the present case, this Honorable Court has the power to appoint arbitrators in the present case, since the seat is in Vindhya and not at Singapore. According to Section 2, subsection 2 of the Arbitration and Conciliation Act, Part 1 would be applicable where the place is in Vindhya. Section 11 is a part of Part 1 of the same Act, and therefore, in the instant case, this Supreme Court has the power to appoint arbitrators. Your Lordships, the Council will be dealing this issue in four sub-issues. That is, lex loci contractus is the law governing the subject as well as the matter in the dispute, the intention of the parties. Thirdly, the applicability of Part 1 of the Arbitration and Conciliation Act 1996, as well as Section 11, subsection 6, read with Section 11, subsection 12, grants power to the Supreme Court to appoint confers power on the Supreme Court to appoint arbitrators in the present case. Your Lordship, the Council has already put forth before this Honorable Supreme Court that as to why in the instant case lex loci contractus will be governing the subject as well as the matter of the dispute. Secondly, the intention of the parties. Here, the intention of the parties were to submit themselves to the laws of Vindhya, especially when it comes to the contractual matters, and naturally the seat will determine the procedural laws applicable to it. Since the councils are humbly submitting before this Honorable Court that the seat is in Vindhya, non-Vindhyan law cannot govern the arbitration agreement in the present case. Your Lordship, in the LMJ in International versus Sleepwell Industries, which is in page 44 of our compendium, it has been stated that if there is an express choice of law to govern the contract, Your Lordship, the council seeks an extension of 3 minutes. Much obliged, Your Lordship. If there's an express choice of law as to govern the contract as a whole, the arbitration agreement may also be governed by the same law. It is therefore resubmitted before this Honorable Court that lex arbitri will follow the lex fori, and therefore the seat will be in Vindhya. And moving on to my third sub-issue, that is applicability of Part 1 of the Arbitration and Conciliation Act 1996 for international commercial arbitration. Part 1 of the Arbitration and Conciliation Act applies to both domestic as well as international commercial arbitration. The juridical seat in the instant case is in Vindhya as submitted before, and therefore under Section 2, subsection 2 of the Arbitration and Conciliation Act, Part 1 will be applicable. Also under Section 20, which deals about what a place of arbitration is under the Arbitration and Conciliation Act of 1996, under subsection 1, parties are free to choose or agree upon what their place of arbitration is. Thus, Part 1 of the Act is applicable and gives power to the court either to refer parties to arbitration under Section 8 or grant interim relief under Section 9 or to appoint arbitrators under Section 11. Moving on to my final sub-issue, that is essentials have been met under when Section 11 subsection 6 is read with Section 11 subsection 12, the Honorable Supreme Court of Vindhya has the power to appoint arbitrators. That is, the power to appoint arbitrators under Section 11 is not merely an administrative power of this Honorable Court, it is a judicial power, and the similar was given in SBB Company versus Patel Engineering Others, which is given in para 46 of page 31, wherein the court has iterated that it is a judicial power. Further, Your Lordship, the essentials have been met. That is, firstly, appointment procedure has been set out in 17.4. Secondly, a party has failed to act under such requisite procedure. In the present case, there is a termination of contract by the respondent, and the petitioners do agree there was a delay in completion of the project. However, the respondent has directly terminated the contract with the petitioner, and there was no reasonable opportunity provided for the petitioners. The purpose of inserting a dispute resolution clause is to achieve a win-win situation, and the respondents are portraying a hostile nature against the petitioners. They have additionally called for a tender, and principles of natural justice has to be complied before termination and a reasonable opportunity is to be given. And the similar was held in 2 cases, that is Hindustan Petroleum Corporation Limited versus Super Highway Services, wherein a principle of natural justice was not complied. Before termination, a reasonable opportunity to represent was not given. Secondly, non-service of notice before termination is in violative of principles of natural justice. The second case being MSAS Motors Private Limited and versus the council seeks extension of 2 minutes to present her concluding arguments. MSAS Motors Private Limited versus Union of India. NHAI gave a show cause notice and then gave a reasonable time as well, and then terminated.
So is there any specific clause in the agreement which speaks about termination?
17.2 clearly which law it 17.2 has a word which.
Now we would like to know, in those cases which you are citing,
Indeed, Your Lordship.
there's a necessity to issue or serve termination notice.
Your Lordship, in one of the case, that is the NHAI case, which the council just presented before Your Lordship, there NHAI had to give a show cause notice because once, as Your Lordships are aware, there was a collection of a toll for the prescribed, there was a collection of a toll and a tender was caught.
Yeah, facts are not relevant. I'm sorry, someone.
Counsel, I wish, yeah, sorry. Is it your case that you wish for this court to make a finding on the merits of the case under?
Indeed not, Your Lordship. Indeed not. Under
And what exactly is the relevance of these judgments?
the council was pointing out that the party, the second requisite under section 11 subsection 6 read with section 11 subsection 12 as to why the petitioners have invoked this particular section and have approached this honorable court. The second essential was that a party has failed to act under the required procedure, wherein in this instant case the petitioners are deprived with an opportunity, because the main purpose of the insert an arbitration clause in the agreement is there if there is any dispute, we can go into, the parties can go into arbitration and assume and come to a conclusion wherein it favors both the parties, wherein in the instant case the council is like to humbly submit that the respondents have portrayed a hostile nature, and therefore the council is trying to put forth these cases to satisfy Your Lordship. The third the council seeks an extension of 1 minute. There are 3 more essentials, and then she will be calling upon the co-counsel to present. The third being the existence of arbitral clause. As we can see from the fact sheet, 17.4 clearly states that each party shall select one arbitrator from the panel of arbitrators. The procedure is clearly specified. The fourth being territorial jurisdiction. In the present case, as under 17.3, we cannot approach the Gotham City courts for appointment of arbitrators because under section 11, only the Supreme Court has the power to appoint arbitrators in the present case, and therefore we've approached this Honorable Supreme Court for the appointment of arbitrators, and the similar has been provided in section 11 subsection 12. The last essential is there is a live issue. Even in the present case, there is a live issue. There is an arbitral dispute, and therefore the council would like to present her concluding statement by saying stating that.
Prior to that, I have a query.
Indeed, Your Ladyship.
Did you approach AAV and ask them to appoint an arbitrator to appoint a panel? Did you issue a notice to them?
Your Lordship, the petitioners have approached the if we look into the fact sheet paragraph 8, it clearly states that there was a delay in construction of the project, and therefore they decided to terminate the same. And despite the airport authority, the petitioners have approached the respondent for the clearance of dues, but without even giving due consideration or a reasonable opportunity, this particular delay amounted to something called as a controversy or a dispute, wherein this had to be resolved through arbitration. However, without the council seeks extension of time to just answer your
council, you have to answer pointed. Did you
indeed
notice or not? Binary answer, yes or no?
Indeed, no, Your Lordship.
No is your answer. That's it. Okay, fine. I think your co-counsel can start now.
Indeed, Your Lordship. It was an honor to argue before the bench. I call upon my co-counsel to present.
To address the bench. Acknowledging the presence of your ladyship's, council seeks permission to collectively address the benches, your lordship. Much obliged, your lordship. Your lordship, this is council number 2.
Can you be a bit louder, please? You're not audible enough.
Indeed, your lordship. Am I audible, your lordship?
Still could be better. Okay, fine.
Your lordship, this is council number 2 appearing on behalf of the petitioners in the case of Kobayashi Constructions Limited and Limgreen Energy versus Airport Authority of India, and this council will be dealing with issue number 3 and issue number 4 of the Moot proposition. In order to answer the question posed to my co-counsel, your lordship, the part of the notice first, as can be seen from the facts of the case, paragraph 7 of the paragraph 8 of the facts clearly states that by the end of December 2020, Kobayashi had completed 70% of the constructions, contrary to what was agreed in the contract. Subsequently, AAV decided to terminate the contract for breach in the following month. Your lordship, in this particular case, AAV, without giving it, as my co-counsel has stated, in 17.2, the concept of termination or anything related to the termination, it amounts to a controversy or a dispute among the parties. Counsel for the petitioners, counsel for the respondents, the respondents in this particular case have went on to issue a tender along with the termination. They did not give us a reasonable opportunity. When the termination was done without following the principles of natural justice, in this particular case, they have also issued a tender. Hence, we approached the Honorable High Court of Magad for the interim relief under Section 9 of the Arbitration and Conciliation Act. But it was denied, and that's why we have approached the Honorable Supreme Court under civil appeal for the interim relief as well as appointment of arbitrators, because the defaulting party in this particular case to refer to arbitration was the respondents and not the petitioners, your lordship. Your lordship, if the bench is satisfied, the council seeks permission to move on to third issue.
Now, the facts also, as you read, says.
Indeed, your lordship.
Currently, the paragraph starts with saying that by end of December 2020, right? It's when only 70% was concluded. Subsequently, AAV decided to terminate the contract for breach in the following month.
Indeed, your lordship.
Which means that the inference may be that, since we do not have the dates with us, that they had intimated you that in the subsequent or the following month they'll be terminating. So there seems to be some kind of intimation to you already, isn't it?
Your lordship, even if we consider there's an intimation that they will terminate the contract in the subsequent month, after the subsequent month or before the subsequent month is completed, it is not clear that it says that the government has also called for a new tender for the completion of the said project. It will be dealt in the fourth issue, why in this particular case, the issuance of a tender or the call for the tender is in prejudice, and why in this particular case the defaulting party will be the respondents and not the petitioners.
Okay, proceed with your issues, counsel.
Indeed, your lordship. Lordship, in the case, third issue states that whether the Limgreen Energy can be made a party to the arbitration. It's most humbly and respectfully submitted before this honorable court that though it's a non-signatory, that the Limgreen Energy is a non-signatory to the arbitration agreement, they can be made a party to the arbitration agreement following the group of companies doctrine. In this particular case, as can be seen from the facts of the case, my first sub-issue being the Limgreen Energy is a wholly owned. The first submission is Limgreen Energy is a wholly owned subsidiary of Kobayashi Constructions. Paragraph number 6 clearly states that on 3rd March 2019, Kobayashi acquired the Limgreen Energy. It's a renewable energy company in Singapore generating power using the solar and wind energy. Limgreen Energy is a wholly owned subsidiary of the Kobayashi, and it's all powers the Kobayashi product. That is why it forms. It forms the group of companies, or it comes under the group of companies definition of.
When was the contract entered?
In May 2016, your lordship.
When was Limgreen Energy acquired?
On March 3rd, 2019, your lordship.
So at the time of entering into contract, this Limgreen was not part of the conglomerate, isn't it?
Indeed, your lordship.
How can you make a party which was not even in existence at the time of contract?
Indeed, your lordship. The moving on to my second limb of the argument, that is the application of the group of companies doctrine. The group of companies doctrine, the doctrine provides that a non-signatory may be bound by an arbitration agreement where the parent or the holding company or a member of a group of companies group of companies is a signatory to the arbitration agreement and a non-signatory entry on the entity on the group being engaged in the negotiation or performance of the commercial contract. In this particular case, Your Lordship, as can be seen from the facts sheet, paragraph number 7, later in 2019, Kobayashi subcontracted Limgreen Energy to supply electricity for the construction of the new airport in Gotham City. Accordingly, Limgreen Energy set up several solar panels in and around the construction site, and the power generation the entire project is now run by the power generated.
Council, we are not disputing that. We are not disputing that it aided you or you had subcontracted or it is not part of your conglomerate. But at the time of entering into the contract, the second petitioner was not in existence at all. So we would only like to know the cases which you are relying. In that case, where the parties which are included, applying this, what you said as group company doctrine. So is it a case where even when the particular person was not in existence, also it was included in that doctrine?
Your Lordship, in the case of Mahanagar Telecom Nigam Limited versus the Canara Bank, the facts of the case, that is the Canfina, which is a subsidiary company of the Canara Bank, was included as though a non-signatory because it performed a part of an obligation under the contract entered between the Canara Bank and the MNTL, Your Lordship. Your Lordship, if we see the chlorochemical case, which the doctrine of group of companies was applied to arbitration proceedings in Dow Chemicals versus Isover, that was the ICC award, and it was later confirmed by the Paris Court of Appeals. This doctrine was applied in the Indian case.
Council, one last time. So my question is not that whether or not Limgreen can be made a party or not.
Indeed, Your Lordship.
Decide that it can be made a party.
Indeed,
But
Your Lordship.
the only difficulty is, so Limgreen Energy was not even in, it was not in, I'm sorry, not rather, it was not in existence. But I would rephrase saying that it was not even acquired. See, it was, do you mean to say that even if there are multiple companies which are acquired subsequently after the agreement, can they still be made a party?
Your Lordship, in this particular case, one of the essentials of the group of companies doctrine is that a subsidiary company or one of the group of companies is performing a part of obligation between the parties, the signatories to the agreement. In this particular case, as can be seen from the facts of the case, Kobayashi subcontracted the Limgreen Energy. Hence,
Yes, that fact we are clear.
Indeed, Your Lordship.
Agree to the fact that it is a subsidiary, and we agree to the fact that it was helping, supporting the petitioner, first petitioner. Our question was, at the time of agreement, Lim Energy or Limgreen Energy was not even related to the first petitioner.
Your Lordship, as I was already stating in the MNTL, Your Lordship, if I may proceed to the...
Yeah, you proceed, understood. I mean, you can...
Indeed, Your Lordship. Essentials for applying the group companies doctrine. It was firstly held in the Indian jurisprudence. It was according to the chlorochemicals was a Severin Trent case. Your Lordship, in the case, in this particular case, there were several principles, there were several essentials were laid down where a non-signatory party could be subjected to arbitration, provided these transactions were with the group of companies. In this particular case, the first essential being the group of companies. That is, in this particular case, as I already said, the Limgreen Energy was acquired by the Kobayashi Constructions, and it becomes a subsidiary company, and that is why it forms a part of the group of companies. Second one, there's a clear intention of the parties to bind both the signatory as well as the non-signatory to the parties. In this particular case, clarifications clearly state that the clarification clearly states that yes, as per the clause under the contract entered between the Kobayashi and AAV, Kobayashi had the right to subcontract. The right to subcontract in this particular case can be construed as the common intention of the parties according to the chlorochemicals case, which my co-counsel has already displayed. That is why the second limb of the argument, that is the second essentials of the chlorochemicals case, that is, in order to apply a group of companies, there is a clear intention. And further, Your Lordship, there is a direct relationship, further, Your Lordship, direct commonality of the subject matter. In this particular case, the Limgreen Energy, which is contributing to the Kobayashi Constructions by setting up the panels, by supplying the energy, is performing its obligation, and hence in this particular case it is having a direct commonality of the subject matter. And fourth essential is composite transactions. Your lordship, in the case of Mahanagar Telecom Limited as well as in the Chloro case, performance of the mother agreement may not be feasible without the aid, execution, and performance of the supplementary and auxiliary agreements. In this particular
Counsel,
case,
I wish to interject because I have a very basic question.
indeed, Your
Uh,
Lordship.
until 2019, how was the petitioner number 1 performing the mother agreement without the aid, execution, and performance of Lim Green Energy, and all of a sudden in 2019, after the acquisition, the performance of the mother agreement was not feasible without their aid?
Your Lordship, the past performance or before 2019, the fact sheets are clearly silent how the Kobayashi Constructions were performing its obligation or supply, Your Lordship. In order to aid the construction of the airport in the Gotham city, it subcontracted the Lim Green Energy, where the Lim Green Energy came into a picture, which forms a group of companies of the Kobayashi, and it's performing the essential element, that is the supply of the solar energy to the project, which is one of the third essential for applying the group of companies doctrine. That is where that is the direct commonality of the subject matter. In this particular case, both the direct commonality of the subject matter for Lim Green Energy as well as the Kobayashi construction is for the construction of an airport at Gotham City, Your Lordship. Hence, the three essentials are fulfilled. Next one is the composite transaction. As I was already stating, performance of the mother agreement. In this particular case, the mother agreement being the agreement entered between AAV, that is the Airport Authority of India, and the agreement between the Kobayashi may not be feasible without the aid, execution, and performance of the supplementary and ancillary agreements. In this particular case, the ancillary agreement or the supplementary agreements is the subcontract between the Kobayashi and the Lim Green. That is why the group of companies doctrine, it falls under the under the fourth essential, that is the composite transactions. And further, Your Lordship, in the case of Mahanagar Telecom Nigam Limited versus the Mahanagar versus Canara Bank, this particular case, this particular court held one of another essential for the application of a group of companies. The fourth essential or fifth essential being the group of companies doctrine has been invoked in the cases where there is a tight group structure with strong organizational and financial links so as to constitute a single economic unit or a single economic entity. In this particular case, reading on or following the fourth essentials as read with the fifth essential, the performance of the contract by the Kobayashi construction is only possible with the aid and performance of the Lim Green Energy. Hence, the 5 essential requisites that is to be followed for the application of the group of companies doctrine has been complied with, and hence, as held in the MNTL versus Canara Bank, the Lim Green Energy will be a necessary and a proper party in order to bring or in the arbitration proceedings, Your Lordship. Your Lordship, further, by following the essentials or by fulfilling the essentials, there are three we can derive at a common conclusion. There are three main intention where or the three main essentials where the group of companies doctrine as can be included, Your Lordship, to bind a non-signatory. First one being the mutual intention. As I already mentioned, the mutual intention is there. Second one, the overall performance in the executing of the contract. In this particular case, the Lim Green Energy is performing, it's a part of the contract. Third one, overall low role played. As I was already mentioning, without the aid or without the power supply of the Lim Green Energy, Kobayashi construction could not in any way construct the airport, Your Lordship. Your Lordship, that is why fulfilling all these essentials, it comes under the doctrine of group of companies, and further, it becomes a necessary and a proper party to the arbitration. That is why the Lim Green Energy can be and should be made a party to an arbitration, Your Lordship.
Counsel, I wish to interject. Sorry. I agree that they can be, maybe it can be argued that they can be made a party, but why would you say that they should be made a party? What is the loss cost to Lim Green Energy if they're not made a petitioner to the present proceedings?
Your Lordship, in this particular case, as I was already mentioning, the fifth essential being tight group structure and single economic unit. In this particular case, the single economic unit or the single economic entity will be both Kobayashi Construction and Lim Green Energy. There cannot be, without one's performance, other performance cannot be done, Your Lordship. Hence, both should be made a party to the arbitration, Your Lordship. If the bench is satisfied, the council seeks permission to move on to the
Proceed.
fourth issue.
Please
Much
proceed.
obliged. Your Lordship, the fourth issue being whether interim relief can be granted. It is most humbly and respectfully submitted before the Honorable Court that in this case, the interim relief can be granted or availed by the petitioners. Your Lordship, as can be seen from the facts of the case, we approached Honorable High Court of Magad. In the clarification, it is given under the note, Your Lordship. The petitioners, that is the Kobayashi Constructions, approached the jurisdictional High Court, and the jurisdictional High Court dismissed the application and also first appeal filed by the Kobayashi Constructions for an interim relief. Subsequently, the petitioners have approached the Honorable Court. In this particular case, according to Article 136 or compliance.
Counsel, just to be clear, what was your first application to the High Court? What was your prayer in that?
Your Lordship, to grant an interim injunction against the respondents.
That is the interim injunction, but what was your main prayer when you first approached the High Court?
When we first approached
the High Court.
Indeed, Your Lordship. When we first approached the High Court, according to Section 9 of the Arbitration and Conciliation Act, in this particular case, the Section 2(1)(e) of the Arbitration and Conciliation Act clearly states that when it's an international commercial arbitration, a party can approach a court. In this particular case, being an international commercial arbitration, they can approach the interim, they can approach the court. In this particular case, the High Court, the jurisdictional High Court of the Magad, and we prayed for an interim injunction. The application was rejected by the Honorable High Court, and we have come on an appeal under Article 136 of the 136 of the Constitution. That is through a special leave petition, Your Lordship.
Correct, but what is your prayer before this court?
Your Lordship, that the High Court of Magad erred in its decision for not granting an interim relief. The council is substantiating why it is an error or why there is a prejudice
No, facts state that, see, 9 states that
Indeed, Your Lordship.
we, despite several requests, did not make the payment. Then this Kobayashi, along with Lim Green, approached the Supreme Court of India for appointment of arbitrators.
Indeed, Your Lordship.
They had to select 2 arbitrators. So what actually is your grievance? Is it appointment of arbitrators or for injunction?
Your Lordship, for the appointment of arbitrator, Section 11 Clause 6 read with 11 Clause 12, in an international commercial arbitration, arbitrators, only the Supreme Court has the power to appoint arbitrators. For interim injunction, we, being an international commercial arbitration, can go to the High Court. The same has been complied and we went to the High Court. Later, the application was...
How many applications are there before us in this case? 1 or 2?
First one is for the appointment of arbitrators under Section 11 Clause 6 read with 11 Clause 12. And
you mean to say you've approached this court, one is by way of an appeal, another one is by way of original jurisdiction. You mean to say there are 2 petitions before us?
Indeed, Your Lordship. Your Lordship, I will be substantiating why in this particular case, the special leave petition or the interim relief, the grant of the interim relief by the Supreme Court is directly relevant to the appointment of arbitrators, Your Lordship. As my co-counsel was already stating, there is a termination. The counsel has already clarified, in the subsequent month, the contract was terminated. Your Lordship, if we look into the 17.2, any dispute, controversy arising out of or in connection with the contract, including any question regarding its existence, validity, or termination, shall be referred to an arbitration. In this particular case, before moving on to the termination, the counsel for the petitioners have never received a proper termination notice or a notice for termination, which that is why they have not complied with the principle.
We are digressing a bit. I mean, that's a separate issue.
Indeed, Your Lordship.
We would only like to know if you're on appeal against the order of the High Court of Magad, then the prayer there was only with regard to an interim relief. You did pray for appointment of arbitrators before High Court of Magad, because as per you, you say that it is an international commercial arbitration, so only this court has jurisdiction.
Indeed, Your Lordship.
Now, when you're an appeal against an order of the High Court where the prayer is only for interim relief, how can you also ask in the same appeal for appointment of arbitrators also?
We are, in this particular case, there are two appeal. One is an appeal and one is an we are invoking original jurisdiction. Your Lordship.
Where does it state in the facts that you have filed 2 petitions separately?
Your Lordship, note says that the High Court of Magad, which is the jurisdictional High Court, dismissed an application. The parties in this particular case are Kobayashi Constructions and Limgreen Energy versus AAV, Your Lordship. And because the appeal was rejected, we came to an High Court under the special leave petition under Section 11, Clause 6, read with Section 11, Clause 12. Because it's an international commercial arbitration, we are invoking the original jurisdiction of the Supreme Court, Your Lordship.
You're expanding the scope of appeal.
Your Lordship, we are not expanding the scope of appeal. We cannot directly come to the Supreme Court for the interim relief, because a remedy or a relief can be availed through the High Court. But in this particular case, the same remedy or the availing of interim relief has been rejected by the High Court, and we are contending that the rejection is against the interest of the petitioners. Your
Have
Lordship.
you stated that in your memorial that you have filed 2 applications?
Your Lordship, in the jurisdictions, it clearly states that we have applied both. That is the 11 clause 6 read with 11 clause 12, as well as we are on appeal for the grant of interim relief under Article 136 of the Constitution, Your Lordship.
Okay.
If I may proceed, Your Lordship. Your Lordship, in this particular case, as I was already stating, in the case of, as my co-counsel has already substantiated, that a principle of natural justice, counsel seeks permission for 3 minutes, Your Lordship. Much obliged, Your Lordship. In the case of Hindustan Petroleum Corporation Limited versus the Super Highway Services, the non-service of the notice, without the non-service of the notice, if there is a termination, it is regarded as the violation of the principle of natural justice. In this particular case, the breach of contract or the termination of contract is a dispute under 17.2, as can be clearly seen. And in this particular case, that is why the dispute first should be given the counsels or the petitioners should be given a reasonable opportunity to represent our case before an arbitral tribunal. But the counsels, by terminating without giving a notice, have also issued a tender. In this particular case, that is why we have went for an interim injunction under the Honorable Supreme Court, under the Honorable for an interim relief before the Honorable High Court, and the High Court rejected. That is why we are filing an application.
Why did the High Court reject? Just to be facts.
Your Lordship, I will be substantiating why in this particular case an interim relief can be availed by explaining.
No, I would only like to know what is the reasoning given by the High Court for not entertaining your application.
Your Lordship, fact sheet is silent as to why the reason is. I will be substantiating why the reasons in this particular case the petitioners can avail an interim relief, Your Lordship. Your Lordship.
See, when you seek an interim injunction under Section 9, that should be in furtherance of the final relief that you will be seeking in your arbitration.
Indeed, Your Lordship, if
let me finish, counsel. Let me finish. You agree with what I said. So what is the relief that you will be seeking in the final arbitration? Will you be seeking for specific performance of the agreement that has already been terminated, or will you only be seeking for damages? Because from what I understand, your representations are only pertaining to the amounts that are due to you. You have not asked them to rescind the termination that has already been issued to you. So what is the purpose that is served by this injunction?
If I may, Your Lordship.
Please, go ahead.
The termination, they cannot do a direct termination, Your Lordship. It amounts to a dispute according to 17.2, without giving a reasonable opportunity for the petitioners to defend themselves or to basically portray their performance, and for the extension or related to anything related to the contract, they did not give us an opportunity to represent ourselves, Your Lordship. And they also issued a new tender for the reconstruction or the completion of the project of the Gotham City, Your Lordship. Aggrieved by this, the counsel for the respondents, as my co-counsel has clearly stated, did not follow the procedure as prescribed under 17.4. Hence, we have approached the Honorable Supreme Court under 11 clause 6, read with 11 clause 12. And because an interim relief was also granted against the issue of the tender or against relating to anything related to the subject matter of the contract, anything related to the subject matter of the contract, that is that's the construction of the airport in the Gotham City, we have approached this Honorable Court, and I'll be substantiating
counsel,
why.
That's very clear that you, yes. I understand that you'll be you're seeking an injunction against the new tender. But what I'm asking you is, are you going to ask for this termination to be set aside and for the contract to be specifically performed? Is that what you'll be asking for in your arbitration? Because in your correspondence, you have only sought for payment of the amounts due to you.
Your Lordship, first one, before the arbitral tribunal, we will be asking if we are allowed, or if we can, there can be a fulfillment of the obligation, that is the construction of the airport. We will be asking for an extension of the contract. Or
Why didn't you ask for an extension to the AAV directly?
Your Lordship, they directly went on to terminate. They did not give us a reasonable
The
opportunity.
following month they terminated. Were you not aware of the deadline, counsel?
We are aware of the deadline, Your Lordship. As I was already telling, the input or the insertion of the dispute resolution clause will be defeated if the termination is followed without giving a reasonable opportunity to represent us before the arbitral tribunal, Your Lordship. In this particular case, they directly went on to terminate without constituting the arbitral tribunal. The whole essence of including the arbitral tribunal or the arbitral clause in the contract will be gone if there is a direct termination. Hence, we are approached. Hence, hence this petition has been filed under 11 clause 6 read with 11 clause 12, Your Lordship. Lordship, I'll be substantiating.
Only as a follow-up question, see paragraph 9, just to what to my sister judge said. See, it appears that from paragraph 9 that despite several requests from Kobayashi, failed to make the payment. So it appears that eventually you only wanted the payments for the 70% completion. If that is what actually,
Precisely.
why would you like the other new tender to be stalled? Let that go on. Let them complete the 30% because public interest is involved in that. Meanwhile, it's like a money suit. Even if you direct to appoint an arbitrator, then you can proceed in the arbitration proceeding to get back your money. Why would you? What is the basis for asking that the new tender should not go on?
Your Lordship, first of all, the agreement is between the AAV and the petitioners, that is the Kobayashi Constructions. According to the agreement made between the Kobayashi Constructions and the AAV, there is a dispute resolution clause included. That is the dispute resolution clause under.
We are all aware of that, counsel. Directly to the point, because we have very limited time.
Indeed, Your Lordship.
Now, justify that. Why would you like the new tender to be stalled or stopped?
Your Lordship, I'll be fulfilling the
Yes.
essentials for an interim injunction, and why in this particular case, the interim injunction should be granted, Your Lordship.
Yes,
Your Lordship,
yes.
primarily.
30 seconds.
Indeed, Your Lordship. Your Lordship, 1 minute, Your Lordship. The Council seeks permission. Indeed, Your Lordship. The essentials under for the grant of interim relief being 3, Your Lordship. That is the prima facie case. First being the prima facie case, as already contended by the petitioners, there is a prima facie case because direct termination cannot be done and the dispute shall be referred to the arbitral tribunal. In this particular case, the respondents have failed to comply with the procedure. Hence, we want to constitute an arbitral tribunal. The procedure, non-compliance with the procedure given under 11 clause 6. That is why we are invoking for the appointment of arbitrators. That is a prima facie case. Second one being the irreparable damage. If the irreparable damage is towards the petitioners, as can be seen, if without the aid and performance, without we have completed the part of performance, that is the 70% of the project, and the insertion of the dispute resolution clause cannot be for the main intention in order to resolve the dispute among the parties without giving an opportunity to represent ourselves. They have terminated.
You have made your point, counsel, regarding not giving an opportunity is being repeated. So that's so. Any other aspects you would like to cover?
Indeed, Your Lordship. Your Lordship, the essential. That is why the essentials. That is the prima facie case. Second one being the irreparable damage and the.
So what is your prayer? What do you want us to pass on?
Indeed, Your Lordship. If I may proceed to the prayer, Your Lordship. Your Lordship, wherefore, in the light of the facts stated, arguments advanced, the authorities cited, it most humbly and respectfully paid before the Honorable Court of India that it may be graciously pleased to adjudge and declare that the arbitration is not foreign seated. The Supreme Court of India can appoint the arbitrators in the present case. Limgreen Energy can be made a party to the arbitration. The petitioners are entitled to interim relief pendent lite. The petitioners are seeking for interim injunction against the respondent and or pass any other order in the interest of justice, equity, and good conscience. And for this act of kindness, the petitioners shall duty bound humbly pay. Much obliged, Your Lordship. It was an honor arguing before the bench.
And we'll consider.
Counsel seeks permission to proceed with the arguments. Acknowledging the gracious presence of your ladyships, Counsel seeks permission to refer to the bench collectively as your lordships. Much obliged. Present counsels are appearing on behalf of the respondents in the matter of Kobayashi Constructions Limited versus Airport Authority of Vidya. The counsel shall be dealing with contentions 1 and 2 in the memorial and shall be taking 22 minutes of the court's valuable time. My co-counsel will be dealing with contentions 3 and 4 and will take 21 minutes of the court's valuable time. We have respectfully reserved 2 minutes for rebuttals. If your lordships are well versed with the facts, the council seeks permission to proceed with the first contention. Much obliged, your lordships. Humbly submitted before the Honorable Supreme Court that the seat of the instant international commercial arbitration is Singapore. And hence, in keeping with Section 2, Clause 2, Part 1 of the Arbitration and Conciliation Act, is not applicable. The Council seeks to establish that the seat of arbitration is Singapore by placing reliance on the interpretation of such pluridirectional clauses, both in Indian cases and in English cases. So the Council would first like to draw your lordship's attention to JSSLC, a decision of the Indian Supreme Court available on flag number 11 of our compendium, wherein the Supreme Court laid down the bright line test to determine the seat of arbitration when it's not expressly laid down in a dispute resolution clause. First and foremost, the court noted that if there is an absence of words such as the tribunal is to meet here or is to hear parties, witnesses, or experts in this place, then the reference to a place of arbitration would actually be the designation of the seat. Because if now drawing your lordship's attention to the annexure, it's crystal clear that none of these terms have been used to indicate that Singapore is merely a place of meeting. Secondly, the Council would like to place reliance on the observation on the test in JSSLC, which lays down that the use of arbitration proceedings as a term would indicate that the entirety of the proceedings should be conducted in a particular place, and that would anchor the entirety of the proceedings to a particular location, which would then lead to the conclusion that it is the designated seat of proceedings. In the instant case, Clause 17.2 clearly lays down that any dispute shall be referred to and finally resolved by making a reference to arbitration at Singapore, which means that each and every meeting of the arbitral tribunal, including the final making of the award, shall happen at Singapore, again indicating that Singapore was intended to be the seat of arbitration by the parties rather than the venue. Finally, the Council would like to draw your attention towards the use of the term shall be. As observed in JSSLC and laid down in the test, the use of the term shall be again anchors the proceedings to a particular location, tipping the scales in the favor of the conclusion that the location referred to is the seat of arbitration rather than the venue. Now, before the Council proceeds to her next proceeds to place reliance on the next precedent, which is Mancas to Impex, the Council would like to quickly point out that the Council for the Respondents placed reliance on NTPC versus Singer, which as a precedent is inapplicable in the instant case because the arbitration clause there laid down that the exclusive jurisdiction and the applicable law were in favor of India. However, the lex fori there was the ICC rules, and it was the determination of the ICC court that London would be the seat of arbitration that came into question in that case. Hence, that precedent is inapplicable in the instant case. However, the Council would like to draw the bench's attention to Mancas to Impex, which is squarely applicable to the instant case. In Mancas to Impex, flag number 12 of her compendium, what came into consideration was an arbitration clause that read, disputes shall be referred to and finally resolved by arbitration administered in Hong Kong. Here, the court relied on two main parts of this arbitration clause. The part that read that the final resolution of the dispute shall be in Hong Kong, and the part that said shall be, to come to the determination that Hong Kong is not merely the venue of arbitration, but is the seat. In fact, available on flag number 17 of our compendium, the court then went on to note that an exclusive jurisdiction clause in favor of the courts of Delhi and an applicable law clause in favor of the Indian law does not dilute the fact that the parties intended Hong Kong to be the seat of arbitration. Here, these two clauses were read together to mean that the substantive law of the contract shall be the Indian law, and that the courts of Delhi would have jurisdiction when it came to matters of interim relief. Hence, to give effect to the entirety of the dispute resolution clause, your lordships, it must be read such that Singapore is the designated seat, and the reference to Indian laws is merely a reference to the substantial laws of the agreement which govern the underlying contractual relationship between the parties. And finally, the jurisdiction of the courts in Gotham is merely jurisdiction in relation to interim review.
Counsel,
That
I'd
says-
like to interrupt you over here.
Indeed, Your
Could you
Ladyship.
please remind the court which party you are appearing for?
The respondents, Airport Authority of India, Your Ladyship.
Counsel, and where is the airport being constructed,
In Gotham City, Your Ladyship.
which is in the state of India,
Indeed, indeed, Your Ladyship. In the country of India.
in the country of India? So now I have a very simple question for you. Why would you choose laws that govern the country of India to be less than the laws governing Singapore? Why would you choose a seat in Singapore, or why would you assess that going by way of 17.2 rather than 17.3, that the seat is at Singapore and not at India, or rather India?
Your Ladyship, first and foremost, as the council has already laid down, the absence of any term indicating that Singapore is merely a place of meeting, state will lead to the conclusion that Singapore was not merely the venue, it was the seat. Further, there is the use of terms shall. There is also the use of terms that leads to the conclusion that the entirety of the proceedings will be conducted at Singapore, which leads to the conclusion that Singapore was the seat. Now, this is the interpretation of the clause laid down in Mancasto Impex. Coming to the practical part of why Singapore would be designated as a seat by the parties, the council at this point can only make a conjecture, one of which would be that Singapore is a hotbed of arbitration, Your Ladyship. That could be one of the
Council-
reasons why Singapore was
Council-
designated as a
Councils, Vindhya as well as Singapore are both signatories to UNCITRAL, and they both follow the same model as regards arbitration. So how would the two be any different?
Your Ladyship, it is an established fact that Singapore is a hotbed of arbitration. It's a well-known fact. That set aside, now relying on the argument advanced by the counsel for the first counsel for the petitioner, as laid down in Enercon India Limited, when the court is met with such an unworkable arbitration clause, it must adopt a common sense approach. Now, Your Ladyship,
The reason why Singapore is hotbed because council like you don't want to conduct the proceedings in India at all. Even though all the Rebuttals is in India.
the council would beg to
We
differ, Your
have a
Lordship.
peculiar situation where a Singaporean company want to conduct the proceedings in India. An Indian company wants to proceed in Singapore. So we would only like to infer that it is only a mechanical objection that you want to raise without any substance.
The council would beg to differ, Your Lordship. First and foremost, the council isn't advocating Singapore as a seat of arbitration. It's the parties that have decided so. Secondly, Your Lordship, if the seat is misidentified, in 2 years, 3 years time, we will be right back where we started, again litigating the fact of which is the correct seat of arbitration. This is why this objection has been brought up, because the curial law here is Singaporean law, and the courts that have supervisory jurisdiction are the courts of Singapore. So even if arguendo,
Council,
the procedure is not,
is this a domestic project or an international project?
it is a domestic project, Your Ladyship. However, that has no pertinence to the determination of the seat when it comes to the interpretation of the clause, Your Ladyship.
What about as regards the appointment of arbitrators? Because I understand from the facts of the case that it is the ex-employees of AAV that shall be the arbitrators in the
Indeed, Your
said matter.
Ladyship. This contention will be dealt with in detail. This leg of the argument will be dealt with in detail under the second contention. However, in keeping with the Arbitration and Conciliation Act of India itself and entry 1 of Schedule 7 read with Section 12 Clause 5, there is no bar on former employees actually being appointed. So,
Can you make the specific distinction between the laws in Singapore and the laws in India, or rather Vindhya, that the specific distinction, because the same can be conducted in Vindhya or even at Singapore when it is the venue, but when it's the seat, what is the specific distinction that sets the Singaporean law apart from the Indian law? Can you just elaborate on that?
Your Ladyship, the council practices in the jurisdiction of India and hence is not an expert in Singaporean law. However, the council would contend that A seat is the basic essential determination when it comes to an appointment procedure. If we go wrong here and the courts of India interject, appoint arbitrators, and then the proceedings are carried out, this award would then be appealed and we'd all be back to where we were right from the get-go, because there is an appointment procedure provided, there is a seat of arbitration provided, and these are being disregarded. If your ladyship is convinced, the council seeks permission
one aspect. So let's assume that this court decides that the seat of arbitration is Singapore. So when you actually make the presentation before the Singapore the tribunal, will they also have jurisdiction or powers to decide whether or not they have jurisdiction? Will our order be binding on the tribunal? Because subsequently, as you said, the appeal would be again in Singapore. So is it possible that the High Court of Singapore may decide that Singapore did not have jurisdiction at all? Can we confer jurisdiction?
Indeed not, your lordship. The courts of India cannot confer jurisdiction upon the Singaporean courts. Here, what the council is seeking to establish is that the seat of arbitration is not Vindhya as contended by the petitioners. This she can only achieve by establishing that Singapore is the seat of arbitration, which is why this entire line of argument is being pursued, your lordship. It is not to get a declaration of the jurisdiction of the courts of Singapore, your lordship. If the council may...
Yep, proceed. Okay, proceed.
Relying on the common sense approach argument advanced by the first counsel for the petitioners, the council would also like to draw attention to Halsbury's Law of England, flag number 2, again cited in Enercon India Limited, wherein it said that if provisions and expressions are contradictory and there are grounds appearing on the face of the instrument affording proof of the real intention of the parties, the intention will prevail over the obvious and ordinary meaning of the instrument, so much so that the literal construction will be abandoned. Now, your lordships, let's look at the intention of the parties. It is absolutely absurd to assume that Singapore is designated merely as the venue here. There is absolutely no convenience attached to such designation of venue. The party, as your lordships have already pointed out, the entirety of the project is being carried out in Vindhya. One of the parties is the statutory authority of Vindhya. All of the witnesses, parties, experts, evidence, all of it is located in Vindhya. Hence, parties designating Singapore as the venue makes absolutely no sense. Hence,
Council, I'd like to stop you over here. Have you referred to Union of India versus Hardy Exploration?
Indeed, your ladyship.
And what is the obiter dicta and ratio decision in that case?
In addition to the designation of a place, there must be some concomitant factor that leads to the conclusion that it is the seat of arbitration. However, your ladyship, the council would also quickly like to place on record that BJS Soma has noted that Hardy Exploration is in contradiction to the Constitution Bench judgment in Balco, wherein the Balco judgment upheld the contrary indicia test as opposed to the concomitant factor test, your ladyship. Hence, since all of these precedents merely have a persuasive value in the jurisdiction of Vindhya, the council would like to urge that the Constitution Bench in Balco combined with BJS and Mankastu will have a greater persuasive value in this court, your ladyship. If your ladyship is convinced, the council seeks permission to proceed. Indeed, your ladyship. So common sense approach here would dictate that the parties identified Singapore merely to designate the seat, not the venue of arbitration, because there is absolutely no convenience attached to this venue. And an arbitral tribunal is always free to change the venue. Hence, there is no meaning in specifying that, specifying Singapore as the venue. Secondly, the council would also like to quickly point out that the first counsel for the petitioners first advocated for a common sense approach, then went into an entirely legalistic interpretation wherein she explained the doctrine of separability and hence stated that 7.3, the term this agreement in 7.3 would refer to the arbitration agreement, not the contract. It's only common sense that no business person, especially when drafting a midnight clause or the champagne clause of dispute resolution, will put in so much thought to dictate that pictorial law is this by referring to the arbitration agreement in 17.2.
Isn't the arbitration clause a part of the contract and hence your interpretation is the entirety of the contract? and now the clause in whole?
Indeed, Your Ladyship, the council is just trying to bifurcate between the two interpretations laid down and is stating that the common sense approach would be.
So what is the agreement that you are referring to over here?
Your Ladyship, the first counsel for the petitioner stated that in 17.3, this agreement would actually refer to the arbitration agreement, not to the contract as a whole. The council is merely trying to point out that that is an extremely legalistic interpretation, which was disregarded in NLCon India Limited, which was cited by the council herself. Hence, adopting the common sense approach, it is the venue. It cannot be concluded that Singapore is the venue. It has to be concluded that Singapore is the seat of arbitration. The council will subsequently also place reliance on certain English High Court decisions. First and foremost, process and industrial development versus Nigeria, flag number 3 of our compendium, wherein when met with a similar clause, the court applied the same test as in Vijay Soma, the meeting place and the use of terms shall, and then went on to note that since the parties were Nigerian and the contract was to be executed in Nigeria, and there was a specific reference to the arbitration clause, Arbitration and Conciliation Act of Nigeria, despite all of this, a reference to London as the venue had to be read as the seat of arbitration because the parties had no convenience in designating London as the venue. So this convenience approach has not just been noted in our own judgments, they've also been espoused in the judgment of the English courts. Next, the council would like to draw your attention to Shanghai, South Asia, flag number 4 of our compendium.
Council, given the paucity of time, I mean, how many minutes do you have for your next issue? Do you have sufficient time? Because last time we had to extend a bit. So if we can move on to your next issue.
Indeed, Your Lord. It's humbly submitted that in the instant case, the seat of arbitration is Singapore, as dictated by both the English High Court decisions and the Indian Supreme Court decisions. And in keeping with this, Section 2, Clause 2 excludes the ambit of this Supreme Court in the appointment of arbitrators under Section 11. Now, proceeding with the second contention, Your Lordships, the council would like to submit that the jurisdiction under Section 11 cannot be primarily exercised because the seat is not Vindhya. Secondly, because the mandatory notice has not been issued. And thirdly, because there is a valid appointment procedure here. Before the council proceeds, the council would like to bring to your notice that the first counsel for the petitioners have already admitted to non-issuance of notice. So it's not a disputed question of fact. Secondly, the first case that they cited, that are switch gears, was one of the cases where the Indian Supreme Court did not exercise its jurisdiction under Section 11 precisely because a notice was not issued before invoking the jurisdiction. That said, the council would now like to draw your attention towards Bharat Sanchar Nigam Limited versus Nortel Networks, flag 18 of our compendium, wherein the Supreme Court laid down that a Section 11 application can be filed only after the notice of arbitration in respect of a particular claim to be referred to arbitration is made, and there is a subsequent failure of appointment. In Prasad Bharti versus Mark Communication, flag number 20 of our compendium, the Delhi High Court explained this position to state that this is a mandatory requirement, and unless a party has failed to act upon the appointment procedure after receiving a notice, the cause of action to exercise jurisdiction under Section 11 Clause 6 does not arise. This is in keeping with the observation of the Indian Supreme Court in with the dictum of the Indian Supreme Court in Indian Oil Corporation versus Raja Transport, flag number 55 of the compendium. Hence, without the issuance of a mandatory notice, the petitioners cannot be here in the first place, asking this honorable court to exercise its jurisdiction under Section 11 Clause 6. That stated, even though the petitioners did not really raise a question as to the validity of the appointment procedure, to put the concerns of the bench to rest, the council will go into the validity of the procedure. Your Lordships, the council would like to draw your attention to Central Organization for Railway Electrification, another Supreme Court decision, flag number 25 of our compendium, where the Supreme Court held that a similar appointment procedure, in fact, an even more restrictive appointment procedure, wherein a 4-member panel was laid down, completely consisting of ex-employees, was a valid appointment procedure. Here, the validity was based on 2 grounds. First and foremost, flag number 26 of our compendium, wherein it was held that retired employees can be validly appointed as arbitrators. Second, since there is a panel procedure laid down and each party has a right to elect its own arbitrator, there is a balance of powers and balance of power. Hence, there is no question of a unilateral appointment being made here. The council would then like to draw your attention to Vostal file, flag number 23 of our compendium, wherein the Supreme Court made a general dictum that any retired employee of a public sector undertaking can be appointed as an arbitrator. Now, this was further developed upon in Government of Haryana PWD, flag number 24 of our compendium, and then it was clearly laid down after interpreting entry 1 of Schedule 7 that Schedule 7 entry 1 does not refer to a former employee. Hence, a former employee can be validly appointed as the arbitrator. Further, your lordships, the council would also like to draw your attention to entry number 31 of Schedule 5. Now, Schedule 5 lays down when there can be a justifiable doubt as to the independence and impartiality of arbitrators. Entry 31 states that if a person has been a former employee within the past 3 years, there can be a justifiable doubt as to independence and impartiality. This means that the legislature has made a conscious choice to leave out former employees from Schedule 7, which prescribes ineligibility, and has gone on to prescribe that after a lapse of 3 years, a retired employee, in case of the appointment of a retired employee as an arbitrator, there cannot even be a justifiable doubt as to independence and impartiality. Hence, a retired employee is unimpeachable. The
Counsel, can you tell us which case this is that you're referring to, which is on the screen right now?
This is entry number 31 of Schedule 5, your ladyship. The council first referred to government.
I'm asking for the cause title of the case.
Your ladyship, this is the Bear Act. The council earlier referred to Government of Haryana PWD, PWD versus GF Toll Road Private Limited, which was a decision of the Supreme Court in 2019, your ladyship. Flag number 24 of our compendium. My researcher will share it with you in a moment. So the council's humble submission here is that in accordance with Schedule 5, the council seeks an extension in the interest of justice.
One question. So you have panel of 5 arbitrators, isn't it? And 2 of them should be appointed, correct?
3 of them, your lordship.
Okay, 3 of them should be appointed from amongst the list that you have provided.
Indeed, your lordship.
Now you are making submissions based on exceptions, saying that as to they are impartial. You are putting the cart in front of the bull, saying that even though they are affiliated with me, even though former employees of my company, still you are trying to establish that they could be impartial. Now, instead of having that, see, the basis of appointment of arbitrators should be that the most basic notion is that it should not be on the face of it biased or capable of being biased. Now, if this is to be accepted, the prayer of the petitioners before the High Court that, appoint an arbitrator, and that too, you cannot have any of them. You could have rather had one retired High Court judge or variety of persons. So now, of course, we accept that they have expertise in the field, but equally is the petitioner also. So therefore, prima facie, we think that having a list of 5 members who all of them are actually of your company and they are forced to choose only 3 among the list that you have provided may not be unbiased.
Your lordship, here the council has a multiple-pronged argument. First and foremost, the legislature does not provide for such apprehensions. The legislature has clearly laid down that an employee cannot be appointed as an arbitrator, and then has gone on to state that a justifiable doubt might be there if the retired employee has left service within 3 years. However, what this leads to the essential conclusion that if the employee has been retired for more than 3 years, even a justifiable doubt does not arise. So the appointment is unimpeachable in keeping with Schedule 5 and Schedule 7. Secondly, Central Organization for Railway Electrification the Supreme Court of India dealt with a similar appointment procedure and laid down that it is a valid appointment procedure because there is a balance of powers since both get to nominate from the panel, and the entire objective, as your lordship stated, was to exercise the expertise of the parties in question. Finally, coming to the practical aspect of laying down a panel, the council would like to submit that the entire objective behind having a panel for arbitrators is to ensure that there is speedy appointment of arbitrators. This was already negotiated between the parties. These parties have entered into multiple contracts beforehand for construction, and they have come to a conclusion that this provides for the most effective dispute resolution mechanism. We have experts that we can nominate in a speedy manner. That is why this appointment procedure is valid, your lordships.
To wind up, you have very limited time, or almost you're done with your time.
Indeed, your lordship. The council would merely like to make her last submission, that is to say, in keeping with TRF Limited and Perkins Eastman, both of these cases noted that a question of unilateral appointment only arises when the appointment is of a sole arbitrator. However, that is not the case here. There is a panel of arbitrators, there is a three-member arbitral tribunal that will be decided, and hence there is a balance of power between the parties. Therefore, the council would like to conclude by humbly stating that first and foremost, Section 11, the jurisdiction under Section 11 cannot be exercised because the seat of arbitration is Singapore. Secondly, because the mandatory notice invoking arbitration has not been issued. And finally, because a valid appointment procedure is in place should the petitioner decide to invoke arbitration in the first place. Much obliged to your lordships.
The council acknowledges the presence of your ladyships and seeks permission to address the bench collectively as your lordships. Much obliged. If there are no preliminary queries, this is council number 2 appearing on behalf of the respondents, and if there are no preliminary queries, your lordships, the council seeks permission to proceed with the third contention. Much obliged. Your lordships, the third contention is whether Limgreen Energy can be made a party to the arbitration proceedings, and it is humbly submitted before this Honorable Supreme Court that Limgreen Energy cannot be made party to the arbitration. The council will be establishing this by putting forth the following arguments: that one, Limgreen Energy is not a party to the arbitration agreement, and there exists no privity between Limgreen Energy and the Airport Aviation Authority of India. Secondly, the doctrine of group of companies is not applicable in this instant case, and Limgreen Energy has not played an active role in the negotiations of the contract. Your ladyship, at the onset, your lordships, at the onset, it has been well established that consent from parties is a prerequisite to an arbitration. This characteristic of an arbitration ensures that it is only the parties to an arbitration agreement that would be parties to the proceedings as that will commence against the parties as well. The same was held in Shahpur G versus Ratan India Powers Limited, where the Delhi High Court observed that the ADR proceedings, the dispute resolution mechanism, rests on consent between parties. An arbitration agreement is governed by the same principles as that of a contract law. And if an arbitration agreement is entered into by one party, the same cannot be binding on parties who are not signatory to such an agreement, as each company is a separate legal entity. Therefore, the company which entered into the arbitration...
I wish to interject here. I understand that a non-signatory cannot be compelled to arbitrate if the said party has not acceded to arbitration. That principle is very clear. In this case, it seems that the non-signatory is very willingly wishing to be a part of the arbitration. So what is the problem that is caused to you if this party is a co-petitioner along with the signatory?
Your ladyship, what has to be observed here is not just the rights of Limgreen Energy, but also the Airport Aviation Authority is in question. If a non-signatory party, without the consent of the Airport Aviation Authority, is made a party to the proceedings, that would essentially open the door for any third party walking around to be made a party to the arbitration proceedings, which was entered specifically for the purpose of dispute resolution between two consenting parties. Now, just because one of the parties is consenting, it does not mean that the rights and obligations which exist of the Airport Aviation Authority can be ignored or overlooked in this instant case. Your ladyships, the concept of privity specifically in arbitration proceedings has been clarified in SR Oil Limited versus Hindustan Shipyard Limited, where in similar circumstances, there was one subsidiary company and there was a contract between an oil company, which is the SR Oil Limited, who was the subsidiary company, and the Hindustan Shipyard Limited, where it was held that if one if one looks at the relationship between the appellant and the respondent, it is very clear that the respondent had given a subcontract to the appellant, and in the said agreement of subcontract, ONGC, which is the third, which is one of the parties who were not signatories to the same. In this instance, ONGC would be the Airport Aviation Authority, was not a party, and therefore no liability arises of ONGC to be made a party to the arbitration that proceeds between SR and Hindustan Oil Shipyards Limited. Your Lordships, the council would like to clarify the facts of this particular matter. The arbitration proceedings was between a parent company and a subsidiary company, while there was another contract for construction between ONGC, which is the oil company, and SR Oils, which is the parent company. So the facts are similar, but not exactly the same. However, the principle still holds good in this particular instance, your Ladyships, your Lordships.
Council would like to clarify only one aspect with regard to determining the parties. Now,
Indeed, your Lordship.
One of the prayers of the petitioners is that eventually they should be repaid or paid their 70% money for completion.
Indeed, your Lordship.
Yes. Will that payment award, any award that is being passed by the arbitral tribunal, will it have any effect on this Limgreen company?
Your Lordships, in this instant case, the payment being made to Kobayashi will not have any impact on Limgreen Energy, as the contract, thus the subcontract exists between Limgreen Energy and Kobayashi. So any dues which are owed to Limgreen Energy can be recoverable through a suit filed against Kobayashi.
So logically, they would be recovering on the payments made by AAV to Kobayashi, isn't it? Can we say
your Lordships, the source of the fund of Kobayashi cannot be restricted to the income arising.
No, that we
out
don't
of
know.
this
We cannot guess. We are only of the view that, see, any payment immediately, the Limgreen will have a kind of a charge, or they would claim saying that they have received money from AAV, therefore you clear my dues. Is that possible?
Your Lordships, at this moment, Council would not like to make any speculations regarding the financial situations of the parties.
We are not speculating. We believe that once an award is passed in favor of the first petitioner, that is Kobayashi, then automatically, right? In fact, the Limgreen should be made a party, so that, as you said, they do not, it should know actually when does first petitioner receive the money, so that it can also impede itself, or rather it can also be party to the proceeding, to the arbitral proceeding, so that an award can be passed, so that whatever, consequently they can receive the money, rather than being unknown, being left in lurch. So, and we are also convinced with the principle that it is a dominus litis as to who can, the master of the suit is actually plaintiffs themselves. So can a defendant say that these parties should not be there? How would you be prejudiced because you're not going to make your payment double? Your cash outgo is going to be the same.
Put this question another way. How does it matter to AAV whether they are paying Limgreen or whether they're paying
exactly
the first petitioner, when the amounts that will be determined, if any, assuming that the arbitration is not in your favor, the amounts shall remain the same. So how does it make a difference to who you're paying?
Correct.
Indeed, your Lordships, the council understands the question and would like to explain the circumstances in this case to effectively answer the questions being put forth. Your Lordships, that would be the case if the remedy for Limgreen to recover their any dues which may or may not be owed to them, if they would be extinguished by the arbitration proceedings between Kobayashi and AAV, it would make sense to make Limgreen Energy a party to the arbitration proceedings. However, the proceedings only have bearing with respect to the contract between Kobayashi and AAV. The terms as to how Kobayashi is financially paying Limgreen Energy for the services of setting up and providing energy for the process of construction is irrelevant, and the facts are silent on that matter. So the only right that Limgreen Energy, if any dues are owed, it would lie against Kobayashi. And further, making Limgreen Energy a party to the arbitration proceedings would cause unjust delay in the proceedings itself, effectively defeating the purpose of the arbitration, which was to resolve any dispute that arises in a fast-track manner. Your Lordships.
aid, because they would also be able to lead evidence to show that with regard to if at all Kobayashi says that X is the amount that I'm required to pay to my subcontractor, and this is what has been completed, whether or not it has been completed as per the requirement. So the subcontractor will be in a better position to lead evidence to show that the completion is actually as per the requirement or with regard to the payment. So obviously, Limgreen will be able to definitely throw very, very important facts and evidences.
Indeed, Your Lordship. But if Limgreen Energy, the only role it's playing is providing facts, then the same can be called, Limgreen Energy can be called upon as a witness during the arbitration proceedings, Your Lordship, by Kobayashi. So as long as there are no rights and obligations which are owed by the Airport Aviation Authority towards Limgreen Energy, then there is no necessity for them to be made a party to the arbitration.
Is there any provision in CPC which says that with regard to misjoinder of plaintiffs, misjoinder of respondent, I mean, if I do not make a responsible party or a required party as a defendant is one aspect, can at best what this Limgreen can be treated as? I mean, can they be misjoinder or what? I mean, how would you say that they should not be a party?
Your Lordships, in the instant case, the council is putting forth that Limgreen Energy is neither a necessary party nor a proper party to the suit. However, the council would also like to clarify that under Section 19 of the Arbitration Act, the rules of Civil Procedure Code are not applicable during the arbitration proceedings. So,
if there is no bar, then it would be, because we believe that their interest is also involved.
Your Lordships, but since there is no relationship between the Airport Aviation Authority and Limgreen Energy, there exists no rights or no claims against the Airport Aviation Authority from Limgreen Energy, which is why there is no much obliged, Your Lordship. Your Lordships, further, the council, once the privity the council would like to proceed with the second sub-contention under the third contention, which is the group of companies doctrine. Your Lordships, now the petitioners have repeatedly placed reliance on Dow Chemicals as well as Mahanagar Telephone Nigam's Company Limited, where Your Lordships, the petitioners have only cited the essentials which are already fulfilled or essentials which are in favor of them. Under the Dow Chemicals versus Isover Saint-Gobain, the court held that the doctrine provides that a non-signatory may be bound by an arbitration agreement where the parent of the holding company or a member of the group of companies is signatory to an arbitration agreement, and that the non-signatory entity on the group has to be engaged in negotiations and performance of the commercial contract. And further, another case cited by the petitioners was the Mahanagar Telephones Nigam Limited, where the court held that the non-signatory affiliate company is going to be held bound in the arbitration agreement if the facts and circumstances can demonstrate that it was the mutual intention of all the parties to bind both the signatories and the non-signatory affiliates in the group. In this case, these two essentials which are laid down in the cases cited by the petitioners have not been met. Further, since Limgreen Energy has not at any stage been involved in the negotiations of the contract, specifically because at the time of entering into the contract, Limgreen Energy was not even in the picture of all this, it is folly for the court to assume that it was the intention of the parties to bind Limgreen Energy into the arbitration proceedings, which is why the contention of the petitioner that it is the mutual intention of all the parties involved to bind Limgreen Energy is misplaced. Further, Your Lordships, in Mahanagar Telephones Nigam Limited, paragraph 10.5 of the judgment states that the group of companies doctrine has been invoked in several cases where there's a tight structured group with organization and financial links so as to constitute a single economic unit or a single economic reality. Now, the court further went on to describe what this single economic unit or single economic reality means, as in such a situation where the signatories and the non-signatories have been bound together under the arbitration agreement will apply, in particular when the funds of the company, that is the parent company or the signatory company, are used to financially support or restructure the other members of the group. Now, the facts nowhere indicate that there is reliance of Limgreen Energy financially or in any other manner to the parent company, which is Kobayashi Limited. Further, your lordships, for a tightly knit group company or for both these companies to be assumed as a single economic reality, there are no such facts which support the same. There are no common offices, there is no same profit center, and there is no sharing of office space, which are essentials laid down under Pascal builders versus Resnick developers for the same to be considered a closely knit company. Further, your lordships, the group of companies doctrine has also been invoked in several cases, including the chlorocontrols case, where it was first laid down in the Indian jurisprudence, where it was held that the discretion of the court has to be exercised in an exceptional, limiting manner, befitting the cases and the necessity, and it has to be done so very cautiously. And normally, only the parties to an arbitration agreement could be referred to an arbitration. Now, when we look at the ratio of all these cases cited so far, it is clear that in only exceptional circumstances where it is of paramount importance that a non-signatory has to be made a party to the arbitration proceedings, along with the essentials fulfilled, such as the intention and involvement of the non-signatory in the negotiation and completion of the contract, is when the same can be bound to the arbitration proceedings. And in this instant case, since none of these essentials have been met, the group of companies doctrine cannot be invoked, making Limbrian Energy a party to the arbitration proceedings. Finally, your lordships, the council would like to place reliance on compare the facts in this particular instance with that of Lakshmi Civil Engineering Services versus GAIL India Limited, where GAIL India contracted for the construction of a raw water plant treatment, and it allowed subcontracting of the same. And the Lakshmi Civil Engineering Company was the one which won the tender and proceeded with the construction of the same. And Lakshmi Civil Engineering further subcontracted the same to 3 other companies and for the execution of the same. In this case, Lakshmi Civil Engineering, the councils of Lakshmi Civil Engineering placed reliance on MTNL as well as the cases already cited. But the court held that in this instant case, the reliance on the same are misplaced, as it does not constitute a single economic reality and the essentials are not met, and GAIL was not bound to arbitration proceedings with the subcontractors. If your lordships are satisfied with the arguments presented for the third contention, the council seeks permission to proceed with the fourth contention. Your lordships, the fourth contention is whether interim relief can be availed by the petitioners. It is humbly submitted before this Honorable Supreme Court that interim relief cannot be availed in this instant case. And the reasons for the same are that the special petition filed by the petitioners is not maintainable, and no interim relief stands to be granted against in favor of the petitioners. Your lordships, an interim relief of injunction cannot be issued against infrastructure development projects. At the onset, your lordships, the council would like to submit that the powers under Article 136, though vast, have only to be exercised in exceptional circumstances. The petitioners have approached the court seeking relief under Article 136, but the purpose of Article 136 was laid down in Bihar Legal Support Society versus Chief Justice of India, where the court observed that the apex court was never meant to be a regular court of appeal against orders made by the High Court or the Sessions Court or the magistrate. It was created for the purpose of laying down the law for the entire country, and extraordinary jurisdiction was granted so that if found that the law is not being correctly enunciated by the lower courts or the tribunals, and it is necessary to pronounce the correct law on the subject, then the court can intervene in this under this particular jurisdiction and grant relief for the same. However, in this instance, there is no miscarriage of justice. The petition filed to the High Court has been rightfully dismissed because there stands no interim injunction against infrastructure development projects, because the Specific Relief Act, the council would like to proceed with the fourth, would like to deal with the fourth leg and the first leg in the paucity of time. The Specific Relief Act Section 20A states that no injunction shall be granted by a court in this suit under this act involving a contract relating an infrastructure project, which is specified under the schedule. And in the schedule, under the head of transport list, the point E includes the construction of airports. So this can be considered This comes under the definition of an infrastructure project. And additionally, under section 46HA, subclause HA, the grounds for injunction to be refused, it was held that if it would impede, injunction cannot be granted against an infrastructure development project if it would cause any delay in the progress of the in the completion of such infrastructure development projects. Further, your lordships, in Parasol Motor Companies Limited versus BMW India, it was held that an injunction which cannot be issued under the Specific Relief Act cannot be granted under Section 9 of the Arbitration Act either, which is why prima facie, it is not possible for the petitioners to seek relief under seek an interim injunction against the infrastructure development project. But ab arguendo, even if we were to consider this provision non-existent, the petitioners do not satisfy the grounds to avail an interim relief. That would be the further submissions of the council. Your lordships, the grounds to grant interim relief are that interim reliefs are in the nature of urgent remedies granted in exceptional circumstances. These are generally subject to satisfaction of the three judicially evolved principles, which is prima facie case, balance of convenience, and irreparable injury. And it is at the onset, it is submitted that none of these conditions have been met in this instant case. In Shiv Kumar versus MCB, the Apex Court objected to an order of injunction as a matter of right. Your lordships, does the bench have a question for the council?
Yep, a practical question, counsel. Are you agreeable to pay that 70% to the extent that they have completed?
Your lordships, the council was unable to hear the question. Could you please?
Are you agreeable? Are you agreeable to pay the compensation or whatever their invoice would be to the extent of 70% that they have completed?
Your lordships, this would be going into the merits of the case, which we will have to take up.
No. Assuming we have been trying to be very practical, if you are agreeable to pay that 70%, then maybe we may not be granting an injunction because because they seem to have made some reminders to make the payment. As the facts say, you failed to make the payments, and therefore want to stop the other proceeding because when their interest is not addressed, right? They don't want you to proceed because for the remaining 30%, there may be an escalated price, which may be based or eat up their whatever overall cost may be more for you. So they may have to eventually sacrifice. But if you're agreeable to pay the 70%, then the need to grant of injunction may not arise. So we would only like to know, are you agreeable to pay the 70%?
Your lordships, the council cannot answer the same without taking the instruction of the party. However, the council would like to submit that the Airport Aviation Authority would necessarily pay any rightful dues which are owed to the contracting companies, and the Airport Aviation Authority is not with the intention to defraud any of the parties.
You would like to dispute the 70% in the arbitration proceedings?
Your lordships, the facts are not clear as to whether the entire amount for the construction of 70% has not been paid. The balance of payment may be something as trivial as 1 lakh rupees. So going on to the merits of how much is owed to it is not at this juncture would not be.
Why would you be in a hurry, counsel? Because maybe there may be some penal charges, but rather dumping them, even because the person has completed 70%, should by all probability be able to complete the remaining 30%. You bring in a new person.
Your lordship, but what has to be noticed here is that there has also been a breach of contract by Kobayashi. So we'll also have to go into the terms of what the remedy for the breach of contract is and calculate the damages with accordance to the same, which is why at this juncture, going into the amount payable either to AAV by Kobayashi for the breach or the remaining dues which is owed to Kobayashi from AAV is not feasible at the moment, your lordships. Because we have to also factor in the breach which has occurred in the instant case and the remainder of the fee which is payable to Kobayashi. Much appreciated. If your lordships are satisfied with the arguments presented under the fourth convention, that is prima facie an injunction cannot be issued against an infrastructure development project And the ab ad Joinder, even if that were not to be considered, the petitioners do not satisfy the essentials for seeking relief under the same. The council would like to quickly recite the prayer.
Yes, please.
Wherefore, in the lights of the issues raised, arguments, advanced authority cited, the counsel for the respondent most humbly and respectfully prays before this honorable Supreme Court that it may be pleased to adjudge and declare that the arbitration is foreign seated. The petition for the appointment of arbitrators is not maintainable. Limgreen Energy cannot be made a party to the arbitration, and interim relief cannot be granted to the petitioners. The court may also pass any such order as it may deem fit in terms of equity, justice, and good conscience. And for this act of kindness, your lordships, the respondent shall ever duty bound, ever humbly pray. Much obliged.
Council seeks permission for rebuttals.
But do we have counsel? I mean, I think we have already exceeded much time.
Your lordship, just 2 minutes or 3 minutes.
2 minutes. Please don't repeat your arguments.
Indeed, your lordship. First one, the counsel for the respondents have stated that the NTPC is not applicable. NTPC case is not applicable, saying that the ratio in the NTPC case that the ICC rules will be applicable and the seat of arbitration is in London. However, the counsel for the petitioners will submit that the NTPC case is applicable, as can be seen from the judgment. The ICC rules, though were specified, it cannot be construed that the England is the place of or the seat of arbitration, is just merely a venue, and the Indian laws matters concerning the arbitration insofar as the main contractor as well as that in contain the arbitration. Second one, the counsel for the respondents have relied on Mankastu case. First one being the whole ratio of the Mankastu case was based on a point or the words administered in. In this particular case, no such words are used. And third one being the English judgment, that is the process industrial parity versus Nigerian judgment. The clause states that arbitration is to be held in Hong Kong. In this particular case, while deciding the case, it was dealt with Section 3 of the Arbitration Act of English Arbitration Act, which states which defines the seat of arbitration. In this this particular case is cited by the petitioner by the respondents cannot be applied, and in this particular case, the Singapore shows that it's merely a venue and not the seat. And the counsel for the petitioners have severed this agreement, the arbitration agreement, from the main agreement in order to show that the Indian laws are applicable, which shows that the lex arbitri, that is the laws governing the arbitration agreement, will follow the lex fori, which is the laws governing the arbitration proceedings, your lordship. And further, the counsel for the counsel second for the respondent most tactically is pointed out that the MNTL versus Canara Bank. He told the counsel for the respondent told that the dues or the essentials are not fulfilled. The counsel for the petitioners have established why the GOC is applicable in this case. That is the doctrine of group of companies. Doctrine of group of companies, there are two main essentials. That is a single economic unit and the composite transaction. The composite transaction clearly states that the performance of the mother contract would not be possible. Counsel seeks extension of 1 minute, your lordship, in the interest of justice. Just 1 minute, your lordship. In composite transaction states the motherly contract would not be feasible without the performance of the Limgreen Energy. As I already stated, the Limgreen Energy has set up solar panels as well as supplied electricity. That is why the performance of the Kobayashi would not be feasible. And further, your lordship, the doctrine of GOC or the group of companies is an exception to privity of contract, as well as is an exception to a lifting of the corporate will or a separate contract entity or a separate legal entity by the companies. And further, your lordship, the essentials of the group of companies, as already dealt in my third issue, is completely fulfilled. And the last limb of the argument that infrastructure project interim injunction cannot be granted. In this particular case, we have explained why the termination in this particular case cannot be made without giving a reasonable opportunity for the petitioners. And further, interim injunction does fall under the category of the circumstances, that is the exceptional circumstances. That is why we have applied for an interim relief. And Section 20 as quoted by the petitioner, Section 20A as quoted by the respondents, that is the Specific Relief Amendment Act, it does not bar the court from considering the interim. Just 20 seconds, your lordship. It does not bar the court from considering that the interim relief, the interim application. And further, we have demonstrated why in this particular case the default is at the respondents and why we avail interim relief, your lordship. Much obliged, your lordship. It was a non-argument for them.
Thank you.
Counsel seeks permission to proceed with the rebuttals.
Also, I think unless you really want to,
Indeed, your lordships. Just to address whatever points has been made in the rebuttals quickly.
1 minute, please.
Indeed, Your Lordships. First and foremost, the dissimilar arbitration clause in NTPC Singer was what was pointed out. I don't know how the counsels for the respondent, counsels for the petitioners got confused about the applicability of that arbitration clause in the instant case. Secondly, the counsel for the petitioners pointed out two words from the entirety of the Mankastu judgment to say that it does not apply here. However, Mankastu relies squarely on BJS Soma, and the bright line test has been satisfied by the counsel for the respondents. Next, the counsels for the petitioners again advanced a legalistic approach of doctrine of separability when drafting the dispute resolution clause, which is often called the midnight clause because parties do not pay much attention to it and hence could not have put so much thought into determining that it was a separate contract within a contract, and that's how the applicability of the curial law will be. That makes for an absurd assumption. The common sense approach dictates that Singapore is the seat of arbitration. Next, Your Lordships, the limb green energy is not essential for the contract because they're a subcontractor. Literally any entity on this planet could be contracted to deliver power for this construction. It was not necessary that it be within the group of companies or the economic entity in question. Finally, Your Lordships, it must be noted that the termination notice here is of no relevance because it goes into the merits of the case, makes presumptions about what was done before the termination or after the termination, and most importantly, the first counsel for the petitioners has already admitted that a notice invoking arbitration has not been submitted. Hence, the entire petition is liable to be dismissed from the get-go. And they've also failed to address the applicability of Section 20A, which bars the grant of injunctions in the case of infrastructure projects. Much obliged, Your Lordships.
Thank you. Now I request Madhu sir to stop the live.